Counsel, are we ready to bring in the veneering? Defense? Yes. Mr. Williams, are you ready for us to bring in the prospective jurors so your attorneys can start asking questions?
Oh, yes, thank you.
Thank you. Let's do that, please. Madam Clerk, they have an hour right now. And maybe give them 5-minute warning. Actually, Deputy, can you have them go back outside? Counsel, approach. Deputy, approach, please. So we need to excuse those jurors that we talked about before we broke for lunch. So we need 14, 26, 45, 47, 48, 56, and 58. Can you bring those jurors in, and then we'll be ready for the remainder. Thank you, sir. You don't even have to take a seat. I just want to make sure we have all of you here, and then I'll have some instructions for you. So do we have Juror 14, Ms. Svager? Is that how you pronounce it? Juror 45, Ms. Mena? Is Ms. Mena here? Okay. Juror 47, Ms. Guerrero. Juror 48, Mr. Walczewski, sorry. Juror 56, Ms. Vasquez. And Juror 58, Ms. Corin. Is there anyone here that I didn't call? Yes, and you are supposed to be here too, Ms. Chinsang. You are all excused. Please go back to the jury office. Let the jury office know that you've been excused from further service. Please go directly to the jury office. Do not stop to tell anyone that is currently still on the panel that you've been excused, and thank you very much for your service. Yes, sir. As soon as they're down the hall, then you can bring in the others. Thank you, sir. Is juror 34 here? Which juror? Okay. Ladies and gentlemen, I apologize. An issue just arose that we have to address outside of your presence. So while you've been waiting and now you're seated, I'm going to ask you to leave again. I want you to know that my motto is early is on time is late, and late's not acceptable, but sometimes we just have to sort of roll with the punches, and if things happen, we have to address them because this is an important case for both sides. So I appreciate your patience. I'm going to ask that you take another 5 to 10 minute break. Please don't go too far. I'm hoping this particular issue is not going to take as long as the last particular issue that required you to come at 1:15 and we started at when we're starting now. But I have to, this is my job, so we're doing the best we can. I appreciate your patience. So texting, tweeting, blogging, emailing, sending or accepting messages, communications of any kind about this case or your jury service. We should be seeking you back at around 2:20. I have 2:09 right now, so about 2:20. Deputy, please let me know when they've left. And then please bring the juror 18 back into court. 18. It's the one Corporal Martin was telling me about. He said, I thought he said juror number 18. We're ready for her. Ma'am, please have a seat. Once you're comfortably seated, deputy will give you a mic, and then you can tell me whatever you want to tell me. And for the record, you are juror 18, correct? Please be seated, counsel. Yes, ma'am.
Okay, so I have a lot going on right now. I live in Boynton, and I have to keep taking Uber to come here. I have nobody to drop me off, and I don't know.
So I want to make sure, I know you're emotional, and I want to make sure that you're calm as you tell me. Just calm down. We're going to get through it. I promise we're going to get through it.
I have a lot going on, and then I'm moving next week. My job don't pay me to come here.
Okay. So just to make sure that the record is clear, you have a job that you are not getting paid if you are not present for, correct?
Correct.
And that is causing you a financial hardship. Is that correct?
It's not even that. It's just the thing that I'm moving next week.
Okay.
And then I have to keep taking Uber to come here, back and forth. I have no ride.
So sometimes people take Uber because they want to take Uber. I'm trying to understand, are you upset and crying because taking Uber is a financial hardship? Or is there, I want to understand, why is that causing you the emotional state that you're in? Deputy, can we get her some Kleenex? Here's my box. You have one? Okay. So, ma'am, I know it's emotional, and I'm just trying to get kind of to the bottom of what the issue is. Are you saying that the Uber is causing you a financial hardship? Ma'am,
Yes, ma'am.
is taking Uber causing you a financial hardship?
Not really.
Okay. So
But
is it the move that's causing you you to be so emotional? Is that I'm seeing you nod your head? Are you saying yes? Because I just need to have it for the record. Is it the move that's causing you the emotional stress right now? Council approach. So, Juror 18, the court is inclined to excuse you. I just need to get Mr. Williams to affirm on the record that he also is okay with excusing you as a juror, okay?
okay, no
Mr.
problem.
Williams, are you okay if we excuse Juror 18 based on how she's feeling right now? Okay. So, ma'am, you're excused. Please go down to the jury office. Please let them know that you've been excused from further service, and thank you. Before we bring in the jurors, I just want to have a colloquy with Mr. Williams just to make sure that we're all on the same page. Mr. Williams, you were present when Juror 18 expressed all of these emotions. Yes, you, Mr. Williams.
Okay.
Yeah, not my. Let's get a mic to you.
Okay.
You were present when juror number 18 expressed a lot of emotions concerning continuing to serve on this case.
Yeah.
All right, and you saw that, right?
Yeah.
And you heard the court say that the court's inclined to excuse her, correct?
Yeah. If she has some problems, then she should go home. Yeah.
All right, that's what I need. I just wanted to make sure that that was okay with you.
Yeah. It's okay.
Still satisfied with your attorneys?
Yeah. They seem to be working out so far.
All right, thank you, sir. Are we ready to bring in the veneering so we can start jury selection?
Yep. I'm ready. Thank you. Appreciate you.
Thank you. I appreciate you too, sir. Let's bring in the veneering. Huh? If I have a feeling they're likely are not going to be going too far. But we'll see. If everybody's here, we'll start. If there's anyone we're waiting for, we'll go from there. It's 3 minutes to. Where's Miss Gazzery? Oh, she's just in the restroom. So, Madam Clerk, you've reflected juror 18 is excused. Thank you, ma'am. Yes, ma'am. council parties, you may be seated. I hope you all enjoyed your extended lunch. We are now at the point where the attorneys will start asking their questions. They each have equal time. The state has the burden. They proceed first. Ms. Walensky, are you inquiring on behalf of the state? Please proceed.
Thank you. Good afternoon. Very lively bunch. So I introduced myself a while ago, back on Friday. So just to remind you, my name is Joe Walensky, and along with Richard Clossy, we represent the people of the state of Florida in this case. So jury selection, as I'm sure you can tell by how long we've been in this process, this is a very important process. And the reason why it's so important is because it's the only time that we as the attorneys get to talk to you. After this process is over, those of you that are selected for the jury get to move into the much more comfortable chairs, but we do a lot of talking at you. We can't stop the trial and say, wait a second, do you have a life experience that's going to make that fact that you just heard hard to digest? So that's why we have to go through this process, and that's why it's so important and it takes so long. We don't want it to take that much longer. So the way I like to look at this process is kind of like speed dating. My goal during this process is to get as much information from you in as little of your time as possible. So the way I like to do that is by asking several different kinds of questions. Sometimes I'll call on somebody specific by your number. Sometimes I'll ask questions by row. And then sometimes I'll ask questions to the whole group. What I ask from you is when you hear somebody's answer, you have something to say, you agree, you disagree, you have something completely different to say. Go ahead and raise that paddle up. We'll get a microphone over to you, and we'll get kind of a conversation going. And that's one of the ways we get as much information from you in as little of your time as possible. The other thing I wanted to tell you just by way of introduction is I know you heard the instruction from the judge that all phones, all electronics are off. I'm sure you've noticed myself and Mr. Clossy, we have computers here, and we even have our phones. It's our burden to present all of the evidence to you. When you see us on our computers and even on our phones, we are actively communicating with our office to make sure this process is moving smoothly for you. So please know we are engaged in this process. We're not checking social media, talking to our friends. All right, with that long introduction, let's get to it. I want to start by following up with some of the questions you've already answered in your questionnaires. Now, because you answered your questions in the questionnaires, we don't know what's really private for you and what is something you're willing to talk about in front of the group. So not trying to expose anybody's personal information. If there's something that I ask you that you would rather speak about not in front of the group, just let us know and we'll mark it down for later. Okay, so I want to first go to juror number 2. That's Mrs. Passius.
Let's just use the paddle if we could. Council approach.
Unless you're more comfortable standing, you don't have to stand.
Sit.
Whatever
sit.
you'd like.
You can sit.
Good afternoon. My name is St. Thomas. About for the discuss for me, the lawyer can make decision about for the case.
So, juror number 2, have you been understanding everything that's been going on in this courtroom so far?
Some I'm understand, some I'm not understand.
Okay. If on a scale from 1 being I don't understand anything, 10 being I understand everything, where do you fall?
I think.
Which number?
What number do you fall?
Therefore, I'm for the number.
How much do you think you've understood so far?
There's so far, I don't know yet.
Okay. All right. Thank you very much, juror number 2. Let's pass the microphone next to you to juror number 3. You don't have to stand up unless that's comfortable for you.
Okay.
Good afternoon.
Good afternoon.
So I want to talk about a couple things.
Okay.
When the judge was talking to everybody about law enforcement,
Mm-hmm.
okay, and you said that you had negative feelings toward law enforcement, and that's fine. We're going to talk. I just want to talk about that, okay? Like the judge said, all witnesses have to be treated the same, whether all lay witnesses, right? Whether you agree with what they do, you don't agree with what they do. Somebody shouldn't get more credibility because they're law enforcement, but also somebody shouldn't get less credibility because they're law enforcement. So it's okay to have negative feelings about law enforcement. What we need to make sure is that you're not starting law enforcement officers' witnesses when they come into this courtroom thinking, I'm already not going to believe what they're saying because they're law enforcement. You follow what I'm saying?
Yes.
So having those negative feelings about law enforcement, do you think that you can start them on that even playing field with other witnesses? Or do you think just by knowing that they're law enforcement, you're kind of knocking down their credibility a little bit?
It's like in the middle.
In the middle?
Yeah.
If I could ask, and for everyone, I know perhaps public speaking is not your forte. Trust me, it's not mine either. But we really do need to get an accurate record. So try to speak as loudly and using your inside voice, but clearly, because the court reporter really needs to take down what is being said. And sometimes when you're soft-spoken, because you're likely nervous, you talk like this and nobody can hear what's being said, and it's very hard. You see what I'm saying?
Yes.
So try to speak into the mic, speak as clearly as you possibly can so we can capture what you're saying, okay?
Okay.
And we know you're nervous, possibly nervous. I don't know, maybe you're not nervous, but I just need you to really speak into the mic. Thank you.
Okay, so can you start law enforcement on the same even playing field as everybody else, or are you giving them a little bit less credibility because of your feelings about law enforcement?
I feel in the middle.
In the middle, what do you mean by that?
Like, it's kind of hard to say. I can't say I could put it to the side, but then again, it's like I can't.
Let me ask it to you this way. I'm going to do like this annoying lawyer thing, and I'm just going to ask you the same question a different way, okay? Do you have a doubt as to your ability to promise us right now you can start all law enforcement on an even playing field with every other witness?
Do I have a doubt? Yes.
Okay. All right. Thank you very much. Juror number 3. Let's go next to juror number 4. Good afternoon.
Good afternoon.
So I have the opposite question, same question, but the opposite direction for you. Because you raised your hand and said you have positive feelings toward law enforcement.
Yes.
Even playing field. Can you
Yes.
Okay. You beat me in my question because you just heard me ask it. You can hold all witnesses to the same even playing field. You're not giving law enforcement that extra bump up just because of your positive feelings about law enforcement?
No.
Okay. Thank you very much, juror number 4. Let's pass the microphone back 2 rows, and I want to go to juror 27. All right. Good afternoon.
Good afternoon.
So I want to talk to you about a topic that came up earlier this morning. I think it was juror number 38 who we'll talk to next. Talked about that idea that little blurb that the judge read to you on Friday was causing you this feeling of, defense might have a lot of explaining to do. Okay. So did you hear the conversation that happened after that with some of the other jurors? We don't necessarily know what that means. Those are just words right now. We haven't heard any evidence. Where do you fall kind of post all of that conversation? Do you still have those same feelings? Because the state has the burden.
Yeah, I think for me to make an informed, well-made, thought-out decision, I would want to hear both sides. I want to think that I can hear
Can
both
I
sides.
interject? Remember food coma? Remember that from this morning?
Can you remind me again?
I will. The defense doesn't have to do anything. So even though you want to hear from both sides, you're not entitled to hear from both sides. And before Ms. Walensky started her questions, before we broke for lunch, everybody affirmed that they would hold the state to their burden and not require the defense to do anything. Everybody before lunch agreed that Mr. Williams, Ms. Gaggery, and Ms. Wilson could play Candy Crush right now, and you would not need to hear from them. If you are changing your mind, that's fine. But we did have this very same discussion this morning, and I'm getting a different answer. I'm not calling you out or making it. I just want to know if there is a change of heart, or are you just not understanding where Ms. Walensky is coming from? We just need to know that.
I understand what you're saying. If there is just one part of the trial where it's just the prosecution putting on their case and there's no defense as to why things happen the way they did from the defense side, I understand that that might be the process, but I wouldn't want to make a decision just based on one side only.
Okay,
May I proceed?
you may.
Thank you. Okay. Thank you, Juror 27. I'm going to have you pass that microphone to Juror 38, right, sort of right behind you. Good afternoon.
Good afternoon.
So my question, I'm going to kind of rephrase my question a little bit. State has the burden of proof, right? We have to prove the whole case. Everything comes from our side of the table. So after kind of hearing the follow-up to I think it was your original comment, where do you stand now?
So earlier I said when the judge on Friday spoke about the DNA evidence that led to the arrest, that was said on Friday. I was thinking about that all weekend, and I couldn't take it out of my mind. Earlier today, I did say I'm a pharmacist, so I understand what DNA means. And it's just not gonna be, it's not gonna fly from point A to point B. It is actually gonna be present. Somebody else earlier today said, well, I'm holding the pedal, so that's how my DNA got there. That's exactly my point, is that DNA didn't get there by coincidence. So that's why earlier I said I'd like to hear from the defense, because I think, I'm not a lawyer nor a judge, I think you're gonna prove that there is DNA, hence this conversation. Then if we don't hear from them, how did it get there? I don't know how to like think about it.
I guess let me ask you this, and I'm not trying to change your mind, but this is kind of for everybody because this opened up to a big conversation. Do you understand that those right now, what the judge read to you, those are allegations, right? That's not evidence. That's not evidence. The evidence hasn't started yet. If you're sitting as a juror, maybe you listen to the evidence and that's not the evidence, right? So have you already decided for yourself that's evidence and I need that explained to me? Or are you going to be able to listen to what happens in the courtroom and accept the evidence that happens here as opposed to kind of that little parenthetical about the case? And I'm not trying to give you one answer or another. I'm just sort of trying to rephrase the question a little bit.
I'm genuinely trying to listen, but the way my mind works, I'm like going, how did it get there?
Okay.
Especially if it led to the arrest, which means there was DNA somewhere else in a different case or whatever that ended up leading to the arrest, because you don't have my DNA. Or maybe
Well,
you do.
I'm
I don't
gonna stop
know.
you right there because we're making assumptions, right? Are you saying that that's going to stay in your mind, even if the evidence in the courtroom is different?
If proven that there was no DNA evidence, then I'll be open. But if there's DNA evidence, it's going to be a tough one.
Okay. All right. Thank you very much, Juror 38. Let's go to Juror 32. Here comes the microphone for you. Good afternoon.
Good afternoon.
So I didn't catch what you do for a living.
I'm sorry?
What do you do for work?
I have my own business,
You have your own business? What kind of business?
landscaping.
Okay.
I have
Did you
Okay.
have a question?
Yeah, my question is my English is not like very fluent.
Okay.
You know,
So
I understand some, not like everything. You know,
Okay. What percentage? How much do you think you've understood so far?
maybe 6 or 7.
Okay.
You know,
All
so
right.
the problem my English is not like I understand more, but I can talk. You know,
Okay.
fluid. You know.
Okay. Thank you very much, Juror
Okay.
32.
Okay, you're welcome.
Let's go to Juror 42, right behind you. Good afternoon.
Afternoon.
So I saw one of your answers to your questions. You answered a question that you've maybe witnessed a crime before. Did I get that right?
Correct. Yes,
Okay. Specifically, have you been a witness to a homicide?
I have. Yes.
Okay. When was that?
I was really young, probably first grade.
Okay. I'm really sorry to hear that. How does that factor in here? We're here for a homicide case. Is that something that, popped in your mind when you heard what the charges were?
Not really. It's long ago, and
Okay.
I don't think it would be causing me to have a bias in this case.
Okay. You don't have a doubt as to your ability to set, it seems so silly to say to set it aside, but to set that aside?
Yeah, I can set it aside and still be a fair juror.
Okay. All right. Thank you very much, Juror 42. Let's go sort of behind you to Juror 55. Good afternoon.
Good afternoon.
So I wanted to talk to you about an answer you gave. You mentioned being a key person in a homicide investigation. Did I get that right?
Correct.
Okay. And specifically in your answer, you mentioned that the case. Well, first of all, when was that?
The year was 2000, 25 years ago.
Okay. What is it? What do you mean by key person?
So it was in federal court.
Okay.
It was a federal case, and the case was sealed by the judge
Okay.
for obvious reasons. It was very high profile. I don't know if you want me to answer your questions now, or I'll be willing to approach because I'm not positive if I can really openly talk about it since it was sealed, but if you want me to, I will.
We'll wait till we can have a private discussion.
Very good.
Okay. Thank you very much, Juror 55.
You're welcome.
Okay, let's go behind you to Juror 64. Good afternoon.
Good afternoon.
So you also mentioned that you have, let's see if I can get somewhere where I can see you. You also mentioned that you have positive feelings toward law enforcement.
Correct.
Did you hear the questions I was asking to some of the fellow jurors in the front?
Yes.
Okay, so that idea that all witnesses have to start on that even playing field, that we can't give law enforcement extra credibility just because they're law enforcement. Are you able to do that, or are your feelings so strong that you'll be giving them that little leg up?
I'm not sure that I could fairly say that I wouldn't give them a leg up.
Okay, so say it another way. Do you have a doubt as to your ability to keep them at that even playing field?
Correct.
Okay. Thank you very much, Juror 64. Okay. So what I want to do is kind of move into some concepts. And despite the fact that on Friday, the judge gave you kind of that, for lack of a better word, blurb about the case, we can't stand up here and talk to you about the facts of the case, okay? So we're going to talk about broad concepts. And a lot of times we use examples that have nothing to do with what we're talking about here. Trust us, there's a method to the madness, but I always like to warn you that sometimes there's that feeling like, why is she asking us this? There's a method to the madness. So let's pass the microphone up because there's no better place to start than the beginning. So for juror number 1, that is you. I want to talk to everybody about premeditation, okay? Because that's a word that gets used a lot, on TV, and we hear a lot about it, but it actually has a very specific definition here in Florida. So what I'm going to do is I'm going to read you that definition, and then we're going to talk about it. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing,
and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. That's what we're going to talk about. If anybody needs me to read it again when I get to you, we can do that. So, juror number 1, did you come into court with an idea of what you thought premeditation meant?
No.
Okay. So the law says that there's no fixed period of time. There's no amount of time that a person has to think about something before they do it. They think about the killing before they kill it. Just that they did. Does that make sense?
It does.
Okay. Can you follow that law?
Yes.
Another thing that is, one of the common ideas about premeditation is this idea of a plan. But what you'll all notice is I never said the word plan in that definition. Juror number 1, do you have any expectation that premeditation requires a plan?
No.
Okay. Do you think that people can make big, life-altering decisions quickly?
Sure. Yes.
Okay. Why?
Well, I mean, people sometimes react without really thinking of the consequences of their actions.
Okay. All right. Let's go to juror number 4. Hi again. Microphone's coming to you.
Hello.
Hello. Did you come in here with an idea of what you thought premeditation meant?
Yes.
Okay. Different than the definition?
Not really.
Okay. Do you have any issues following that law that there's no fixed time period and that there's no amount of time a person has to think about something before they do it and there's no requirement for a plan?
No.
Do you agree with the concept that people can make big life-altering decisions quickly?
I see it every day.
Okay. How so?
I'm a nurse, and patients' conditions can decline very quickly, and the families have to make a decision whether to keep them or let go, and it's done within seconds.
Okay. All right. Thank you very much, juror number 4. Let's go next to juror number 5. Good afternoon.
Good afternoon.
Did you come in here with an idea of what you thought premeditation meant?
Yes,
Okay. How did it match up to the definition?
about the same.
Okay.
Yeah, about the same.
Okay. Any issues for you following the law that the state doesn't have to show at a certain amount of time that a person thought about doing something before they did it, or that we don't have to prove a plan?
No.
Okay. What about this concept of people making big life-altering decisions quickly?
Yeah, I think that happens every day.
Okay.
We all do that. I mean, not we all, but people are doing that regularly every day. for
Okay.
sure.
So even if it's a decision maybe you wouldn't make quickly, that you might think about for longer, would you agree that it could happen quickly?
Absolutely.
Okay, let's go next to you to juror number 6. Good afternoon.
Good afternoon.
What do you think? Did you come in here with an idea of what you thought premeditation meant?
Yes, it was pretty much the same.
Okay. This idea that we don't have to prove a plan and we don't have to prove a certain amount of time that a person thought about something, just that they did think about it. Can you follow that law?
Yes.
Any issues with that?
No.
What about the idea of people making big, life-altering decisions quickly?
Yes, it's possible.
Okay. When you say possible, that's a word that we use here in the courtroom. You'll hear about it. What do you mean by that? Do you think it's not common? Is it something that seems outside of kind of the normal?
No.
Or is it just semantics?
I didn't mean it that way, but yes, I have seen it done.
Okay.
I've seen quick decisions having to be made.
Okay. So like, for example, have you ever heard of somebody like going and buying a house sight unseen?
Yes.
Okay. Would you do that?
No.
So like, that's sort of what I'm talking about, right? And obviously we're talking about buying a house versus committing a crime. So it's different, but that's sort of what we're talking about. So it's not necessarily something outside of the realm of possibilities for you?
No.
Okay. Thank you very much.
You're welcome.
Let's go to juror number 7. Good afternoon.
Good afternoon.
So you're a former lawyer.
Yes.
Okay. What made you switch?
The hours,
Okay. How long did you practice?
about 7 years.
I'm sorry, you said
7 years.
7? Okay. And now you're in management?
Yes.
Okay.
Like
I'm
financial.
reading your body language a little bit. It was like kind of.
Yeah, I'm a consultant right now in basically management consulting related to data and AI.
Okay. How long have you been doing that?
I kind of happened into it starting in '94.
Okay. And do you ever, stretch those lawyer muscles
Every day.
every day? How so?
It's all applied common sense and communication, what I do.
Okay. Ever do any criminal practice or internships or anything like that?
No, I did corporate.
Okay. Do you find yourself interested in those kind of things?
It's interesting.
Okay. All right. So let's go back to what we were talking about. Let's talk about premeditation. Did you come in here with an idea of what you thought it meant?
A general idea, yes.
Okay. Did we meet your expectations, or is
Yes,
there
you-
something missing?
Yes, you did.
Okay. The idea that the state doesn't have to prove a plan or a fixed time period, is that going to be an issue for you?
No.
Do you think people can make these big life-altering decisions quickly?
Yes.
Okay. Let's go next to juror number 8. Good afternoon.
Good afternoon.
I'm going to switch it up on you.
Okay.
We're going to talk about that too, but we're going to add to it a little bit. Okay? So let's talk about premeditation first, and then we'll add to it. Did you come in here with an idea of what you thought it meant?
No.
Okay. So you're one of those sponges the judge was talking about,
Yes.
right? Can you follow the law as it's written?
Yes.
Okay. Are you going to have any expectation that the state's going to have to prove a plan or a certain amount of time that somebody thought about something?
No.
Okay. This idea that people can make big decisions, maybe decisions you wouldn't make, quickly.
Correct. Yes.
Okay. Is that something that you can accept as something somebody would do?
Absolutely.
Okay. So I want to talk to you about motive. Okay. Because there's a lot of talk about what the state has to prove. Okay. And what you're going to hear if you're selected as a juror, and this is for everyone because we're going to keep building kind of on what we're talking about. The judge is going to tell you this is what the state has to prove. One of the things you're not going to hear is motive. And I think it was juror 51 that said, I'm going to be looking for the who, what, where, when, and why, which is fair. We're allowed to look for that. But the state doesn't have to prove the why. We just have to prove that something happened, or we have to prove that this happened and that this defendant is the one who committed the crime.
Right.
Okay. What do you think about that we don't have to prove motive, that you may never know why?
I think we would like to know the motive, but we understand that it's not possible.
Okay. You're okay with that if that's an
Yes.
open question for you.
Right.
Okay. Let's go next to you, to juror number 9. Good afternoon.
Good afternoon.
Let's start right where we left off, talking about the why. That's not something the state has to prove. How do you feel about that?
I think that's interesting. I hadn't thought about that before. I don't watch a lot of crime shows, but I always heard the motive was talked about. So I'm not sure what I think about it.
Okay. I guess what we want to know is it something, knowing that we don't have to prove it, is it something that you'll require because, you're either curious or it feels like I can't have that kind of unanswered question?
I don't think so. If the evidence is strong enough, I won't need that.
And the evidence has to be strong, right? We have to prove the case beyond a reasonable doubt. We have to make it to our burden, but we only have to prove the things that we have to prove. And the judge will tell you what those are. And motive's not going to be there. So if we meet our burden on what we do have to prove, but you don't have a motive, are you going to be able to find the defendant guilty if we meet our burden?
I think so. It's hard to say now, but
it's hard. And this is what I meant by, we can't talk about the facts. I can't say what if you have this and this and this. But is your hesitation because you've never done this before?
Yes.
Okay, that's fair. All right, thank you very much, juror number 9. Let's go to juror number 10.
Hello.
Good afternoon. How are you?
Good. How are you?
So I know on Friday, I'm doing well, thank you. I know on Friday you mentioned that you weren't feeling well.
Mm-mm.
How are you feeling now?
I still feel not great.
Not great. Okay. Have you been able to, for lack of better words, stay with us? I know sometimes when I'm sick, it's hard to kind of concentrate. How has that been for you?
Friday was really tough. I feel better now to advocate for myself. Yes.
Okay. All right. So let's talk a little bit about some of these concepts. Let's talk about motive. The fact that the state doesn't have to prove motive. How do you feel about that?
I'm not sure how I feel about it.
Okay, and that's fair. You actually don't have to have feelings about it. What you have to do is follow the law. And when I say that, I mean you have to tell us if you can't follow the law.
Okay.
Okay. So basically, what it comes down to is sometimes in a trial that's something we know, and sometimes it's something that we don't know, but it's not something we have to prove.
Okay.
Okay, and that's you're not going to see it in the instructions because it's not something we have to prove. So if we prove our case beyond a reasonable doubt, but you still have that outstanding question about, but why?
Mm-hmm.
Are you going to be able to find the defendant guilty, or is that outstanding question going to be something you're going to require from the state, even though the instructions don't require it? The law doesn't require it.
Because you don't have to prove a motive, I will have to accept you don't have to prove a motive.
Okay. All right. And the premeditation. Was there anything about that that was surprising to you, that we don't have to prove a plan, we don't have to prove an amount of time that somebody thought about something, just that he did?
I find it interesting. This is new to me, so I like knowing the information.
Okay. Do you think people can make big life-altering decisions quickly?
Yes.
Okay. All right. Thank you very much, Ms. Williams. Let's go behind you to juror number 20.
Hi there.
Good afternoon. So I'm going to switch it up on you a little bit, just to keep everybody awake. All right. We live in a world where people don't necessarily walk around announcing their intent, right? Like I've been kind of moving back and forth. I've had a sip of my water, but I didn't announce that I was doing those things. I just was kind of doing them. So in a world where people don't announce what they're going to do, how do you know what somebody's intent is? What do you have to look at to determine somebody's intent?
Body language. You have to look at the the environment, the surroundings. I'm good there.
Okay. All right. Let's pass the micro. Well, before we do, how do you feel about no motive? The idea that we don't have to prove it.
Definitely can accept that, because this is very helpful to lay down the instructions so that we know exactly what we're looking for.
Okay.
Well, the instructions are not laid out yet. I give you the instructions. Ms. Walensky is giving you concepts to discuss. But ultimately, we want to ensure that you are going to be able to follow the law as instructed.
Noted, and yes, I will.
Thank you.
All right. Let's go next to you to juror number 19. Good afternoon.
Good afternoon.
So what do you look at in a world where people don't announce their intent? Like if I were to walk over, I am announcing my intent because it's really hard to do this example without announcing my intent. But if I'm about to walk over and I take a pen from Mr. Clossy, but I didn't just tell you I did it, I just did it. How do you know that I did it intentionally?
I'm sorry. This last Friday, I need to say that my English is second language.
Okay.
I know doesn't allow for participate this. I understand a little.
Okay. How much of what we've discussed so far do you think you've understood?
How much of what the percent?
How much? Yeah, the percent.
3%.
50?
3.
3. Okay.
What do you do for a living, Em?
What?
What do you do for a living? What do you do for work?
And the work?
What do you do for work?
TC Maxx store.
Pardon me?
TC Maxx store.
TJ Maxx store. Thank you.
You're welcome.
Can I proceed?
Yes, ma'am.
Thank you. Let's pass the microphone over to juror number 17. Good afternoon.
Good afternoon.
Okay, so let's talk about some of these concepts. So you saw me take the pen from Mr. Clossy. I've since returned it, but you saw me take it. Without me announcing, I'm walking over. I'm going to take his pen. I'm going to walk back to the podium. How do you know what my intent is?
It's the first time you can talk with him, I think.
Okay. Can you look at what I'm doing to determine if I'm doing it on purpose or intentionally?
No,
Why not?
because you are going you direct to the pen.
Okay.
No talk with nobody.
Okay. All right. The definition of premeditation. Did you understand that definition?
No, exactly.
Not exactly. Do you want me to read it again?
Yes.
Or was there an issue with understanding it? I can read it again if you want.
Yes, please.
Okay. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Okay? So do you understand that?
Yeah.
Okay. So there's no requirement that we prove that he planned it, and there's no requirement that we prove that he thought about it for a certain amount of time. Can you follow that law?
No,
Why not?
it's not correct. It's not good. It's no.
Okay. Okay. So even though that is the law, you're saying you can't follow it, cannot follow it. Yeah. Okay. Let's go next to you to juror 16. Good afternoon.
Good afternoon.
Okay. I'm going to see if I can get this pen example to land.
Okay.
Okay. How can you tell that what I did was intentional?
I can't.
Okay. So in a world where people don't announce their intent, that they do things, we do things every day on purpose, right?
Yeah.
But we don't talk about it.
Correct.
So how do you know somebody's doing something with intent?
You don't.
Okay. So is it that second paragraph that I read, the question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. So can you look at a person's actions and determine based on their actions that they did something intentional?
It's possible. It
Okay.
depends on the evidence.
Depends on, right?
Yeah.
Because we know that people do things with intent all the time,
Correct.
right? And they don't announce it.
Correct.
Can you do that? Can you look at the evidence and make that kind of determination without kind of like a pronouncement?
If there's enough evidence beyond a reasonable doubt, I believe so, yes.
Okay. And what about this idea that we don't have to prove a motive? We don't have to prove the why. How do you feel about that?
I'm okay with that.
You're okay with that?
Yeah.
Okay. And this idea that we don't have to prove a fixed time period or a certain amount of time that somebody thought about something, just that he did. Can you follow that?
Yes.
Okay. Do you think people can make big life-altering decisions quickly?
Yes.
All right. Let's go next to you to juror 15. Good afternoon.
Afternoon.
All right. How do you determine somebody's intent if they don't announce it to you?
My interpretation is based on actions and the evidence that goes behind it. If I see valid reason for it, I see the intent.
Okay. All right. What about the idea that we don't have to prove a motive?
That doesn't matter to me. I believe the actions matter more than the motive.
Okay. And premeditation. Did you come in with an idea of what you thought that meant?
I mean, I understood the definition, but I don't believe there is anything that is premeditated unless you really want to carry it out.
Okay. Can you follow the law on premeditation?
Yes.
Okay. Thank you very much. Let's go, just to keep everyone awake, let's go behind you to juror 24. Good afternoon.
Good
I promise
afternoon.
I'll come back to the rest of the second row. I know you're probably not disappointed. I'm coming back, though. I promise. Good afternoon.
Good afternoon.
Okay. So how do you determine somebody's intent if they don't announce what they're doing or what they're going to do?
You can.
Okay. So then how do we prove premeditation, right? How do we prove somebody's intent if they don't announce it first?
Facts and evidence.
Okay. So what kind of things? So like in my situation where I take the pen, what are you looking at to determine if I did it intentionally?
Your actions.
Okay. So like the walking over?
Body language, your actions.
Okay. Okay. So you can by looking at kind of surrounding circumstances. Would you agree with that?
To some degree, yes.
Okay. Premeditation, did you come in with an idea of what you thought that meant?
No.
Okay. Can you follow our definition?
Absolutely.
Okay. No, you're not going to require the state to prove a plan or a certain amount of time that he thought about it?
No.
Okay. And what about the idea that we don't have to prove motive?
Counsel approach.
think we were talking about motive, right?
Yes.
Okay. Motive. The fact that the state doesn't have to prove a motive. Can you follow that?
Yes.
Okay. Do you think people can make big life-altering decisions quickly?
Yes.
Okay. Let's go. Keep everyone awake. Let's go behind you to juror number 34. Good afternoon. I'm going to get somewhere where I can see you.
Hello.
How are you today?
I'm fine.
How do you determine what somebody's intent is if they don't announce it to you?
From the environment and what their motions are or
Okay.
actions. Yeah.
Okay, so that's something you think is possible that you can kind of look at those things and determine what somebody's intent is.
Right.
Okay. The definition of premeditation.
Mhm.
Was it surprising to you? Did you come in with an idea of what you thought it meant?
That was very close to what I had thought.
Okay.
Yeah.
The fact that the state doesn't have to prove a plan or a certain amount of time, just that there was a period of time. Can you follow that?
Yes, I can.
Do you think that people can make big life-altering decisions quickly?
Yes, they do.
Okay. I sounded like you were going to say something after that. No? Okay. What if it's a decision you wouldn't make?
Everybody's different in how they.
Okay, so
proceed
that's not
and
going to
make
factor in.
decisions. Yeah.
Okay. Let's go next to you to juror 35. Good afternoon.
Afternoon.
Premeditation. Did you come in with an idea of what you thought that meant?
Yes, but that was pretty close.
Okay, you were on the money.
Yeah.
Okay. So are you okay with the idea that the state doesn't have to prove a plan or a fixed time period?
Yes.
Okay. And you can follow that definition?
Yes, ma'am.
Do you think that people can make big life-altering decisions quickly?
Absolutely.
Would you do that?
Not
Okay.
that, no.
No, I mean
No.
like make a
Yeah.
big, like, buy a house.
Yeah. Oh, no.
I sight unseen.
No, depending on the severity of like the outcome that it could have, then
Okay.
yeah, and no, but yeah.
You could see how it could
Yeah.
happen. Okay. What about the fact that the state doesn't have to prove a motive?
Yeah. The only thing that matters is there was a crime and the fact that you get charged the right person with that crime.
Okay. All right. Thank you very much. Let's go next to you to juror 36. Good afternoon.
Good afternoon.
Let's talk about premeditation. Did you come in with an idea of what you thought that meant?
Yes.
Okay. How did it line up with the legal definition?
Perfect.
Okay. That's good. Can you follow it?
Yes.
Okay. The idea that the state doesn't have to prove a plan or a certain amount of time that somebody thought about doing something before they did it. Can you follow that?
Yes.
Do you think people can make big life-altering decisions quickly?
Yes.
Okay. Strike that. The idea that we don't have to prove a motive. How do you feel about that?
I agree with it.
Okay. It's my job to listen to what you say and to see how you say it. Are you hesitating, or is that just my
Just
imagination?
me.
Okay. All right. So you're okay with that?
Yes.
Okay. Let's go to juror 37. Good afternoon.
Good afternoon.
Try to get somewhere where I can see you. Trying to do these in different orders just to keep everybody awake a little bit. Motive. State doesn't have to prove a motive. Do you have any issues with that?
No.
Is that something that you may want to know?
Sometimes things don't have a motive and they just happen.
Okay. Do you think people can make big life-altering decisions quickly?
Yes.
Okay. The premeditation. Did you come in with an idea of what you thought that meant?
A general idea.
Okay. Did it include things like a plan?
Yes.
Okay, so knowing that it's different a little bit than what you thought, or kind of sometimes how it's portrayed on TV, or can you follow the definition the way it's written and not require us to prove like a plan or a certain amount of time?
Yes.
Okay. Let's go to juror 39. Microphone's coming to you. Good afternoon.
Good afternoon.
Let's talk about motive. State doesn't have to prove a motive. Can you follow that?
Absolutely.
Okay. Why do you think that is?
You may not get a motive. In every case, there may not be a motive. Someone might just do it.
Okay. So even if it's something maybe you want to know as a person, you're
Right.
accepting of the fact that you wouldn't get to know it here in court?
Yes.
Okay. Premeditation. Did you come in with an idea of what you thought that meant?
I did.
Okay. How did the definition kind of line up with what you came in thinking?
About the same.
Okay. Did you have an idea that maybe it required a plan or a certain amount of thought that went into it?
No,
Okay. Can you follow our definition?
I
or
can.
the legal definition, I'm sorry.
I can.
Okay. And do you think people can make big life altering decisions quickly?
I think they can.
Okay. Let's go next to you, to Juror 40. Good afternoon.
Hi.
I bet you could tell me the questions now, right?
Sure.
I'm not going to have you do that. I just, usually by this time, everyone's like, we know the questions, we get it. Premeditation. Did you come in with an idea of what you thought that meant?
Yes.
Okay. And how did the legal definition line up with?
The same.
Okay. Are you going to require the state to prove a plan or a certain amount of time that, somebody thought about doing something?
No.
Okay. Do you think that people can make big life-altering decisions quickly?
Absolutely.
Okay. State doesn't have to prove motive. How do you feel about that?
Okay.
Okay. Any hesitation about the idea
No,
that you
I
might
mean,
not
everybody
get a lot?
wants to know why someone did something, but if there is no reason, there is no reason.
Okay. All right. Let's bring the microphone forward to Juror 30. Good afternoon.
Good afternoon.
State doesn't have to prove a motive. How do you feel about that?
Sometimes you don't have the motive. If the person that committed the crime
Can you
didn't
speak
say-
up a little bit?
If the person that committed the crime did not say anything, what's the motive? The reason why he committed the crime, you might not know it.
Okay.
So you have to go with the evidence as you have.
Okay. Did you come in with an idea of what you thought premeditation meant?
Yes.
Okay. Did you think it meant, a plan or, thinking about it for a certain amount of time?
Yes, premeditation means that you have the time to think about.
Okay.
Think about something.
Okay. Did you understand the legal definition as I read it?
Yes,
Can you follow it?
absolutely.
Do you think people make big life-altering decisions that maybe you wouldn't make quickly?
They do all the time. Yes.
Okay.
Yeah, that's happened.
All right. Thank you. Let's go to Juror 29. Good afternoon.
Good afternoon.
So on Friday, we talked about the fact that you had some childcare concerns. Did I get that right?
Yes.
Okay. Were you able to work out your childcare concerns? Like when you need to pick up your kids?
The time is 4 o'clock.
Okay. So just so we know, what time do you have to pick up your kids?
4.
At 4 o'clock?
Yeah.
Okay. Every day?
Every day.
And what time do you have to take them?
Take them 7.
In the morning? 7 in the morning?
Yeah.
Okay. All right. Let's talk about the concepts. Okay. Premeditation. Did you understand the definition when I read it?
Yes.
Okay. Can you follow that?
Yes.
Are you going to require the state to prove a plan or a certain amount of time that somebody thought about something?
Yes.
Okay. Those words aren't in the definition. We don't have to prove a plan. Can you follow that? Or are you
Yes.
going to require a plan?
Follow that.
You can follow it? Yeah. Do you think that people make big life-altering decisions
Of course.
fast?
Yes.
Okay, maybe even though it's not a decision you'd make?
Yeah.
Okay. And what about the fact that the state doesn't have to prove a motive? How do you feel about that?
I don't want to say something is not.
Say that again, please.
Can you repeat it again for me?
Sure, I can repeat it again. The state does not have to prove a motive. We don't have to prove why this happened, just that it happened.
You didn't work
country.
before the
No.
daycare center? Okay. You can proceed, Ms. Walensky.
Let's go to juror 22. Good afternoon.
Good afternoon, ma'am.
This idea that it's the same burden, regardless of the crime. Can you hold us to that beyond a reasonable doubt?
Yes, ma'am.
You're not going to raise the burden because it's first degree murder?
No, ma'am.
Okay. And the other things that we've talked about, can you follow the definition of premeditation?
Yes, absolutely.
And what about the idea that we don't have to prove a motive? Are you going to require us to prove something that the instructions don't require us to prove?
I would not require you, but as a human, some part of me would want to know, but I do not require it for this.
Okay. So, and listen, everybody's human, right? Everybody wants to know. But let's say you get to the end of the case and that we've proved it beyond a reasonable doubt, but you don't know the why. Are you going to be able to find him guilty?
Yes, ma'am.
Okay. Thank you. Let's go to juror 31. Good afternoon.
Good afternoon.
Okay, this idea about the burden of proof. Can you hold us to the burden of beyond a reasonable doubt?
Absolutely.
Okay, you don't think that you're going to raise that burden because it's such a serious charge?
No, but if I have to compare the two things, I'm going to judge you more than I'm going to judge him because it's up to you to make sure that you do your job.
Of course.
In the same seriousness.
We have the burden, right?
Exactly.
Okay. Can you follow the law on premeditation?
Yes, of course.
Okay. And do you think people can make big life-altering decisions quickly?
Oh, yes, I do
Okay.
all the time.
Okay. Let's go to juror 33. Good afternoon.
Good afternoon.
Okay. The burden of proof that we have to prove this case beyond a reasonable doubt, whether it's first-degree murder or stealing a pack of gum. Can you hold us to that burden?
Yes.
Are you going to raise the burden because it's such a serious charge?
No.
Okay. And the law on premeditation, did you come in with an idea of what you thought that meant?
Yes.
Okay. How did it line up with the definition?
Pretty similar.
Pretty similar? Thank you. Judge, may we approach?
You may.
Thank you. Okay, juror 33, you still with me? Okay. We were talking about premeditation. Okay. Can you follow the law as it's written?
Yes.
Are you going to require any proof of a plan?
No.
And what about the fact that the state doesn't have to prove a motive?
I understand.
Okay, you can follow that?
Yes.
Do you think people make big life-altering decisions quickly?
Yes.
Okay. And I know you're all thinking, gosh, there's still a lot of us left. How long is this going to take? She said speed dating. I meant it. So here's what we're going to do. Just hold on to the microphone. I'm going to be done picking on you. But here's what I want to do. I think I've talked to most of you in the first 4 rows. So starting in row 5, I want to kind of talk about some of these concepts, but we'll do it by a show of hands just so we can not keep you here all for the rest of time. Okay, so starting in row 5, is there anybody that thinks, you know what, I've heard the definition of premeditation, I just can't follow it. I need that plan. I need that fixed time period. Anybody, and I guess I should say by a show of paddles. In row 5, I'm not seeing any paddles. How about row 6? And row 7? Okay, is there anybody, I know I talked to most of you about it, but anybody else that feels that way? Okay, let's go back to row 5, and I want to talk about motive. We talked a lot about, that the state doesn't have to prove why something happened, just that it happened and that this is the person that did it. Is there anybody that is sitting there thinking, I get it, I hear what you're saying, but for me to find somebody guilty, I have to know why? Okay, we have a hand. Let's go to, that's juror 57. Let's get a microphone to you. Coming. Good afternoon.
Hi, good afternoon. I raised my paddle because this is my first time listening to the full description of the word the premeditation definition is
All
really
right.
long.
I give you the definition of premeditation. Ms.
Right.
Walensky gave you an example to elicit responses. Okay, so let's just be clear. The instructions come from the court, not from Ms. Walensky. All right? Everyone understand that? Thanks. Go ahead.
The reason why I raised my paddle is just because I was wondering if there is a way to know more as to why the state doesn't have to prove there's the provable why.
So that's a question. That's up to the
I'll
legislature,
interject.
right?
I'll interject. The jury instructions are from the court. The history of it comes from the Supreme Court. There's a whole committee. We all kind of agree that these are some standard instructions. And the elements of the charged crime are statutory. So the legislatures, when they wrote the law concerning first-degree premeditated murder, provided certain elements. And the legislature, when doing that, decided that motive in Florida is not an element to the charged crime. So I will give you, at the conclusion of the case, if you're selected as a juror, what the elements that the state must prove. And those are the elements that you will have to find whether the state has proved facts to support each and every element beyond and to the exclusion of every reasonable doubt.
Mm-hmm.
And if that crime does not include motive, will you be able to decide whether or not the state proved each and every element of the charged crime?
Yeah, right.
Effectively, are you going to follow the law?
I understand, and I'm a law-abiding citizen. I think
I'm not suggesting you're not. We're just trying to elicit
yes.
what.
What I'm trying to say is
Okay.
yes.
Thank you, Ms. Walensky. You can proceed.
Anybody else? And the question on the table is anybody else having that feeling of, listen, I get it. I understand that the law says the state doesn't have to prove why this happened and the state doesn't have to prove a motive. But for me, I just have to know before I could find somebody guilty. Anybody in the whole room? Okay, I'm not seeing any hands. Is there anybody that feels like, you know what? And we'll just go whole room. Is there anybody that feels like, you know what? This is a more serious charge, and I think the burden should be higher. I'm not seeing any paddles. All right.
59.
Oh, we do have a paddle. Okay, let's go to juror 59. Good afternoon.
Good afternoon.
Okay, so let's talk about it. You think the burden should be higher?
I would assume so. On the scale from stealing a gun versus murder, I think if there's a scale, that should be higher.
Okay, and that makes sense, right?
So, Mr. Desir, I'm going to interject. As you may remember from maybe Friday, we all have a lot of thoughts. We all have a lot of desires. However, in this particular instance, it's whether you can follow the law. Are you going to be, whether you like the fact that the burden is what it is, or you dislike the fact that the burden is what it is, are you going to be able to hold the state to the burden?
Yes.
All right. Ms. Walensky can proceed.
So, juror 59, you still have the microphone?
I do.
Okay, so, what it really comes down to is it's much more about how high the burden is for stealing the pack of gum and not about how low the burden is for first-degree murder. Does that kind of help you? There's no scale. It's just because I know you said if there was a scale, it seems like this should be higher. There's no scale. It's all the same, which is just how high the burden is for stealing a pack of gum. Does that make sense?
Sure.
Does that kind of help you with that idea? Are you going to be able to hold us to the burden of beyond a reasonable doubt and not raise that burden higher?
No.
No, you can't? Or no, you won't raise the burden?
I won't raise the burden, but
okay.
I will expect
a lot, right?
Yes.
Beyond a reasonable doubt's a high burden. And I want to talk to you about what I mean by raising the burden. Okay? In order for something to be proven to you beyond all possible doubt, wouldn't you have needed to be there and see it yourself?
no.
Why not?
I wasn't here for slavery, but I know it happened.
Okay. All right. So the reason why it's beyond a reasonable doubt is because in a courtroom, we rely on evidence of people talking about things that happened in the past. Okay? Can you do that? Can you rely on that kind of evidence, or are you going to require more?
I can rely on it.
Okay. All right. Anybody else feels like, you know what? I feel like the burden should be higher for this kind of charge. I am not seeing any hands. Okay. Let's go to juror 21. I'm coming back to you. Microphone's coming to you, hopefully. I don't know if we can get an assist. Here we go. Here it comes. Okay. I'm going to talk to you about something that you had in the questionnaire. You
No
mentioned
problem.
that your brother has been arrested for a federal crime.
Yes.
Did I get that right?
Yes.
Do you feel like he was treated fairly?
I'm not sure because I didn't go to the court cases.
Okay, that's fair. What about like by police?
Possibly. I'm not sure.
Do you have any, lasting feelings about law enforcement or about the court system because of your brother? Or is it kind of, you weren't there, you don't know what happened, so it doesn't play a part for you?
I'm about what's right and what's wrong. So therefore, I can't really comment on his situation.
Okay, that's fair enough. Thank you. Let's go to juror 39. And I'm sorry, I'm really bouncing this microphone all over the place. It's another way to keep everyone awake. Hi again.
Hello.
So you mentioned that your son has been arrested.
Mhm.
Was that here in Palm Beach County?
It was.
Okay, how long ago?
It was like 2.5 years ago.
2.5 years ago?
Yeah.
Did he have to go to court?
He did.
Okay. So myself and Mr. Classy, we weren't the prosecutors on
Mhm.
your son's case, but we represent the state of Florida, which is the same prosecuting agency, and we actually work at the same office that prosecuted your son.
Mhm.
Is that something that bothers you?
No, not at all.
Okay. Is there anything about the way your son was treated or the fact that your son was prosecuted by our office that would affect your ability to be fair to the state in this case?
No, nothing.
Okay. Thank you. Let's go to juror 50 behind you. Good afternoon.
Good afternoon.
I want to talk to you about your cousin. You mentioned that your cousin has been to jail and was not treated fairly. Okay. How long ago was that?
5 or 6 years, probably.
Okay. Here in Palm Beach County or somewhere else? Thank you.
I'm not sure if it was Palm Beach, but it was close by.
Okay. Who did you feel like your cousin wasn't treated fairly by? I'm not sure that was the best way to ask that, but I'm hoping you got it.
It was more so the people in the actual jail than the arresting officers.
Okay. Is there anything about the fact that you feel like your cousin wasn't treated fairly that would affect your ability to listen to law enforcement testimony or to, be fair to either the state or the defense?
No, ma'am.
Okay. Thank you very much. Let's go to juror 46.
Hello.
Good afternoon. I saw that you also felt like you were not treated fairly.
Correct.
Okay. How long ago was that?
Year and a half, July of 2024.
Okay. Was it here in Palm Beach County?
Yes.
Okay. Who did you feel like you weren't treated fairly by?
And being arrested by, I didn't feel being treated fairly by the procedure of what was done as far as the breathalyzer test and the
Okay.
machine itself.
Okay. So the part of like the arrest process. And
Yes.
okay. Is there anything about your experience? I guess I'll say with law enforcement, but it's much more kind of the system and the way the system worked that would affect your ability to be fair to law enforcement witnesses and to start those law enforcement witnesses on the
No.
same even playing field?
No.
What about-
It wouldn't change my view now. No.
And what about the court system? Any long-lasting feelings about the court system that would affect your ability to be a juror?
No.
Okay, you're not going to hold it against the state?
No.
Okay, and the fact that myself and Mr. Classy, we work for the same office that would have handled your case, does that bother you?
No.
Okay, thank you very much. Let's go to juror 66. Microphone's coming to you. Good afternoon.
Hi.
So you also mentioned that you felt like your son and your nephew, let's see if I can get some more where I can see you. Your son and your nephew were not treated fairly. Same questions for you. Was that here in Palm Beach County?
Yes.
Okay. How long ago?
My son been in prison for like 10 years now.
Okay, and I'm sorry to hear that. Is there anything about that you think you would hold against the state? Feeling like your son wasn't treated fairly either by the police or by the system?
Well, yeah, by the system.
By the system?
Yes.
Okay. So we're kind of asking you to be part of the system.
Right.
How do you feel about that?
Not good.
Not good. Do you think you might hold that against the state, that we're asking you to listen to facts that the state is proving against another person?
Not necessary to hold it against them, but I've been, a victim of murders, so it's kind of hard being here today.
Okay.
Mhm.
Okay. So there's a lot going on.
Mhm.
Do you think that that would affect your ability to be a juror in a case like this?
Yes.
Okay. All right. Thank you very much. Now, ladies and gentlemen, I'm going to ask just a couple questions to the whole room. First question, is there anybody that feels like because of a religious or a moral reason they cannot sit in judgment of another person?
Let me interject. You're not judging another person. You're judging whether or not the state has met the elements of the charged crime. So let's revise that. Go ahead.
I'm not seeing any hands. And my last question for you is, what I want to know is, if we had a role reversal and you were standing up here, is there anybody that's thinking, gosh, if I were picking a jury for this case, I would want to know this about me? So it's kind of like a big catch-all question. Is there anything that you think we should know before I sit down? Okay, I'm seeing hand. Can you raise it? I just can't see what number it is. 44. If we could pass the microphone to 44. You want to do it after? Sure. Okay, so if we could mark down 44. Anybody else? Number 10? Okay. And 59.
Wait, I'm sorry. I missed the after 44. Who is the next person? Number 9? 9, 10.
Lots are going up now. 59, 52, and 41, and 3.
52, 41, and who?
3.
Thank you.
And 7.
And 3 and 7.
And I think 49. Was 49 up? 49 was up. Okay, ladies and gentlemen, thank you so much for your time and attention. I appreciate it.
Council approach. Ladies and gentlemen, each side has equal time, so it's another hour and 15 minutes of questions from the defense. We're going to take a break because there's some individuals that said that they had information that they wanted to share with the court. I'm going to ask those individuals, well, juror 3, I want you to stay here. The rest of you can go outside, stay close by. Once we finish discussing the issues with juror 3, we'll discuss the issues with the other folks that raised their paddles and wanted to have a discussion with the court. The rest of you can enjoy your break until 4 o'clock. It's our expectation we're going to come back at that time to allow for the defense to have their opportunity to inquire, and we'll continue on with the jury selection process. Enjoy your break. No texting, tweeting, blogging, emailing, sending or accepting messages, communications of any kind about this case or your jury service. We'll see you at 4. Deputy, if you could get juror 3 of the mic so we can start as soon as the veneering has left for efficiency purposes. Deputy, please confirm when the veneer is left so we can start inquiring. All right, please be seated. Juror 3, you indicated that you wanted to have a discussion with the court outside the presence of the rest of the panel.
Yes.
And what did you want to tell us?
I wanted Miss Joey
Walensky is her last name.
Willis-
Could you speak closer to the mic so I can hear you? Thank you.
Miss Walensky to repeat your question because I wasn't sure which info we were able to share with the courtroom.
Which what, ma'am?
Her last question, I was curious about that. Which information can we share?
We want to hear anything that you feel is necessary for the parties to be able to identify whether you can be a fair and impartial juror in this case. Other than what she's already asked, is there something that was not asked that you feel compelled and required by law to share with the court so they can make that necessary determination?
Okay, great. It's about a few things. So first is on the questionnaire that we filled out on Friday. It asked if we were a victim of a crime or if we've been arrested for a crime. I put in both. So the first one was, is there anyone here? Okay, great. The first one was I was a victim of a crime. It was domestic violence of my mother, and I had to go to court, in this court specifically, to testify against her.
When you say this court, you mean this courthouse?
Yes.
Okay.
This courthouse specifically. It was very violent. So she basically took an item, a teapot, and bashed my head. And I had to go to the hospital because I was bleeding excessively from my head. So I don't do well with blood or like anything graphic, anything like that. Also, I was arrested for a crime last year, and you were the judge on my case. I wasn't convicted, but when I went through the processing of, going to the jailhouse and everything, that also leads to my question why I said I felt strongly against law enforcement. I think that was the question, because of how I was treated in the jailhouse. So that's also a thing.
Well, thank you for letting us know about that. Any questions from the state? No, any questions from the defense? No, Judge. All right, thank you, ma'am. You can enjoy your break, and I'll see you at 4.
Okay.
Thanks. I think the next juror is 7, correct? That's correct. Juror 7. While we wait for juror 7, deputy handed me a note about juror 29 having child pickup issues.
Yes, that's what he said as well, that he had by 4.
About juror 29? Yes. Do you all agree to excuse him or not?
Defense is okay with excusing him.
Mr. Williams, are you okay with excusing juror 29?
Yes, that's fine.
Okay. So can you bring in juror 29 now and then bring in juror 7 thereafter, please? Pardon me? No, 29 first and then 7. Mr. Williams, if you, my JA, if you could tell me what the calendar looks like tomorrow so we can determine the start time, please. Mr. Juror 29, you're excused. Please go down to the jury office. Let them know that you're excused from jury service. Please just go directly down to the jury office and not have any conversation with the other members of the panel. Thank you. We're ready for number 7. So you can sit anywhere. We just need to get you a mic. Oh, you have it? All right. You're
I have the
here.
mic. Could I approach the bench?
Well, it needs to be in open court so Mr. Williams can hear.
Okay.
You can have a seat, though.
Okay.
Thanks. Yes, sir.
So I filled this out in the form, but I can't remember the
I'm sorry, I can't hear you.
I filled this out on the form. I'm not sure what words I used, so I just wanted to be clear. When I was about 7 years old, I was sexually assaulted, and the man was convicted.
Okay. Thank you for letting us know. Any questions from the state? Defense?
Is there anything about that experience that you believe would affect you if you were picked as a juror in this case?
I think I can be objective, but it was obviously pretty horrific.
Of course, of course.
So,
and I'm sorry.
It's going to bring back a lot of memories. Well,
I didn't.
It will bring back memories.
Okay. And do you have a concern that something in the trial may trigger such that you're unable to fairly and impartially?
I think I can be fair.
You think you can be fair, or you can be fair?
I can be fair.
Thanks.
Okay. Do you have any doubt?
I mean, enough to come back in and raise it, yes.
Of course. And we appreciate that. That's all we want to know. Is it the nature of the crime in this case that you think might be triggering, or just the whole trial experience?
I think it's the age of the person who was killed.
Mm-hmm. And so, we have a concern. Both sides want the jurors to be as fair and impartial as possible. And do you have a concern that, given the age of the victim in this case, that your personal experiences, or given your personal experience, that you would that would interfere and come in to influence your view of the evidence, possibly in favor of the state or the victim's family, like that?
I will be impartial.
And so, kind of like, to put this another way, if hypothetically you were sitting accused of a crime, like of a murder in this case, would you want yourself as a juror in this case?
I think I would be a good juror.
All right, nothing further.
Thank you, sir. I'll see you at 4. It seems like it's juror 9 now. Yes, sir. Ma'am, you can sit anywhere. Once you're comfortably seated, you could let us know what you wanted to tell us. Counsel, you may be seated.
Thank you.
Mr. Williams, too. Yes, ma'am.
I just wanted to mention that my younger brother was killed in a hit and run accident, and all the details of this case are much different than that. I'm not sure that I'll be able to handle the nature of this case emotionally. It has already been pretty heavy, and we haven't gotten into it at all. And I'm not sure if that plays into anything, but I wanted to be open about that.
Thank you. I appreciate that. Any questions from the state?
Does that cause you to have a doubt as to whether you could be fair, or is it just you're worried about emotion?
I don't think it's a doubt of fairness. It's a doubt of if I'll be able to keep it together during the trial.
Okay, and let me ask you this. You know, one of the things that we need from all jurors is that they can view all the evidence. And, you know, whether they like it or not, they have to view all the evidence. Are you going to be able to view evidence of a homicide, or is that something you think could trigger that?
It produces a lot of anxiety to think about viewing evidence of a homicide. That's, yeah,
Because
I've
of-
already thought about that and thought that
Okay.
it would be very difficult.
Okay, thank you. That's all I have.
Thank you, defense.
No questions.
Thank you, ma'am. You can go back outside. I'll see you at 4. Deputy Juror 10.
Thank you.
Thank you.
Juror entering.
Ma'am, you can sit anywhere and then let us know what you wanted to tell us.
Hi, I just wanted to clarify Friday. The judge asked if there was anyone who was not able to do this because of a hardship. I learned that I have 2 official days of jury duty that is approved by my job, and I cannot do a 9-day trial. And I was curious if there was any information I needed in order to proceed as a juror, or if I would be penalized.
Well, we
if I'm
can
not.
provide your employer a letter to say that you're here serving on a jury. If I'm not quite sure what it is that you're asking, and I do have some questions. Where, if you would remind me, where do you work?
I work at ABC's Fine Wines and Spirits.
Okay.
I don't get paid other than that. So I was curious how would I have to choose being a juror over my getting paid at my job, basically?
As to the payment, I can't necessarily answer that question. As to the service, you are
Required to serve.
Yeah.
Okay.
I would send you a letter to you, or give you a letter so you could give to your employer to say that you are serving on a jury. Some companies, most companies like ABC that has hundreds of employees, know that that's a responsibility, so they pay their employees. Some of them don't. That's the question I don't have an answer to. But as to the protection of your job, the letter would protect you from losing your job.
Okay. I just wanted to let everyone know before I proceeded that
Right.
information was clarified.
All right, thank you for letting us know.
Thank you.
Yeah. Oh, I'm sorry. Wait. I'm sorry. I forgot. The attorneys can ask questions too. So have a seat.
Sorry. Go ahead.
Hi again.
Hello.
So let's talk. I'm not going to call it worst case scenario, maybe for you. Let's say you're selected and you're here with us all week and a little bit next week. Are you going to be able to focus on what's happening here in the courtroom?
I will have to be. I want to be honest. I would love to be a part of the process. But I would be thinking about how I'm going to pay a week's worth of time.
Okay. All right. Thank you.
Thank you.
Do you want to ask your employer? Because we would like to be able to factor in your issues with the determination as to your ability to sit on the panel. Do you need to make a call to your employer to tell your employer that the judge will give you a letter saying that you're here serving on a jury and the trial will last X amount of days? And will they pay you?
I will have to ask. I would love to ask, yes.
Okay, would you take this opportunity during this break to do that and hopefully provide us an answer?
Yes.
Thank you, ma'am.
Thank you.
I think it's now 41, Deputy 41. And then after 41, it's 44, just to kind of keep it seamless.
41. And after 41, I'm going to need 44. So 44, stand on deck.
Anyway, not at 41.
Juror entering. 41.
Once you're comfortably seated, then you can just let us know what you wanted to tell us. Counsel, please be seated.
Okay, this didn't have to be private, but since I was at the end of the list, I just wanted to say that I wish that I hadn't heard about the DNA, because I understand that intellectually the state has to prove everything and that I have to be a sponge, but I just can't get it out of my head. And at a gut level, it's really hard to come back from that, to give the defense a fair shake, which he's entitled to.
Thank you.
So I just want to say that.
I appreciate that. State?
No questions.
Defense?
No questions.
Thank you, sir. I'll see you at 4. Deputy 44 is next, and then after that, it's 49. Good to see you. Good to see you, sir.
Tell 49 to be ready. Juror entering.
We can. I think it's 41. You're juror 41, right?
44.
Okay. We asked for. Did we? We already did 41. Sorry. I'm sorry. I'm behind. Ma'am, once you're comfortably seated, just let us know what it is that you wanted to tell us.
Yeah, I have an anxiety disorder.
I'm sorry. Say that again.
I have an anxiety disorder. Causes a lot of like extreme and unnecessary guilt.
Wait 1 second. Say it once more.
It creates a lot of extreme and unnecessary guilt. It would be very difficult for me to sit on a trial like this.
Thank you for letting us know. Any questions from the state?
So, as a juror, you're just, as the judge told you, you're just the judge of the facts. You just decide if the state proved the case or not. Are you worried that that feeling, that guilt feeling, will keep you from being able to do that job of just deciding the facts?
Yes.
That's all I have. Thank you.
Defense?
No questions.
Thank you. You can. I'll see you at 4. It may be a little later than 4 because we're still going through questions. But if you just be around by 4.
Yeah, sure.
Thank you.
Thank you.
Deputy 49 and then 52.
Okay.
And you can sit anywhere that's comfortable. And then once you're seated, we'll be seated and you can tell us what it is you wanted to tell us. You can have a seat and tell us what you wanted to say.
Thank you. When we were talking, when we were discussing about the premeditated, whether you will follow the rule and etc., I got only some part of it. I could understand. I couldn't understand entire thing. That a chewing gum, somebody stealing a chewing gum is equivalent to a bigger thing.
Okay. Let me break that down because part is something that I want to make sure that you understand, and then we'll talk about the chewing gum because that's an example. All right.
Okay.
Did you hear Miss Walensky's recitation of the premeditation? Did you hear what she said? Did you understand that?
Partially, not all of it, but partially, little bit enough to understand it. But my where I come from is if there is a mental, mental inability, incapacity, for some people, whether there is a motive or whether there is not a motive, they may still be doing it, something which is incorrect or improper in the law space, and still they may not be, I come from that angle. I'm totally different. What I am talking to you is totally in a different direction, I understand. But what I mean to say is, if somebody is mentally incapacitated, they are not, they can, I have made decisions in a thing to buy a house. That was in Florida when we decided to come here. So it can happen. So there doesn't need to be a motive, but what you're doing right and wrong, and you have to follow the law. I totally get it. But there are people who cannot follow. Law is not something they can follow when their mental capacity is not there.
Okay. So if I'm hearing you correctly, ma'am, you understood what the words Ms. Walensky was saying when she was giving the definition of premeditation. You understood that.
I understood that there can be a way that people can make a decision in a split second and do something which is wrong, right?
Are you going to be able to follow that instruction?
Yeah, I'll be able to follow that instruction, but where I come from, there are people, to be very honest with you, I have many people whom I meet who are mentally not in that stage.
I understand what you're saying. I'm trying to be very focused, right? So I hear you talking about mental incapacities and the like, and that wasn't part of the instruction. You would
Yes.
Okay.
That I agree.
And that we don't know whether that's going to be part of the instruction.
Yes.
Ms. Walensky's inquiry was using that as an example. Would you be able to follow that?
Yeah, I will follow the law, whatever it is. Whatever.
I appreciate that, ma'am. Any questions from the state? Defense?
No questions.
Thank you, ma'am.
Thank you.
Deputy Juror 52 and then 55.
49.
Juror entering.
Sir, once you're comfortably seated, you can let us know what you wanted to tell us, okay?
Do I sit down?
Yes, you can, please.
Good afternoon.
Please be seated, counsel. Yes, sir, what did you want to tell us?
Well, I just wanted to basically say what I feel.
I'm sorry, can you put the mic close to
Oh,
you?
sorry. Basically, I want to say how I feel. I feel like I'm not fit to be a juror. I feel like, to be honest, I don't really understand everything that's going on. It's my first time. I don't these big words saying I don't understand.
What is it that you don't understand? Let me break that down if I could. Have you been able to understand the words coming out of everybody's mouth?
Basic words. Once it comes to like them big words, I speak 2 languages, so
What's your other? What's your native language?
Spanish. At
Spanish.
school, I was like the ESOL program, so I don't really. I needed more help to understand and learn each year.
Okay.
I feel like.
So let me ask you this: of everything that you've heard between Friday and today, if you were to give a percentage of what you've understood, what would be that percentage of what you understood?
I only understood that's a criminal case. That's about it.
Okay. Any questions from the state? From the defense? All right, thank you, sir. You can go back outside.
No problem.
Deputy 55 and then 59.
Juror entering.
So once you're comfortably seated, then you can tell us what you want to say. Just have a seat wherever you're comfortable and then let us know what you wanted to say. Anywhere. Pardon me? Anywhere. Anywhere you want to sit.
Okay, so I had written down in my bio in the pamphlet that I was involved in a case in 2000. It was a federal case. It was sealed by the judge in D.C. federal court in Washington. Do you want a little bit of detail about the case?
I want to
would
know
assume?
whatever you feel is necessary for us to understand why, so that the attorneys can determine whether you can be a fair and
Yeah.
impartial juror. You can. All right, sir, you can proceed.
So it all happened at a very rapidly. The reason I put it down and I mentioned it because it was the murder of a police officer. I happen to have gotten to know the person that murdered the police officer. I was in the automobile business. I've been in the automobile business for 30 some years. And the gentleman had come in and I sold him several cars and so forth. And he started talking to me, blah, blah, blah. So the murder occurred. It was a huge shock. There was a national manhunt. He was on the run for about 2 weeks. It was so high profile at the time. There was a show, America's Most Wanted. And I can remember John Walsh pulling up with the TV crew and doing the whole thing on the show. It was pretty high profile. He had told me a few intimate details about himself and his family and so forth. So I knew of some New York connections. And I was able to ultimately lead law enforcement to apprehend him. And so I had to be on standby. I sat before a grand jury, so forth and so on. I did the right thing. I don't think it's going to affect me in this case. If anything, it probably, it taught me a lot. Let's just put it that way. It taught me a whole lot more than I bargained for, but I kind of need to tell you about this because you would probably, being sealed, not find out unless I told you, so I needed to tell you.
Thank you. State, any questions?
So something I saw in the questionnaire that you wrote
Yes.
is it had to plead because of the nature of the crime.
Okay.
What did you mean by that?
Okay. Great question. Okay. So the case happened, and believe it or not, he dropped evidence on the scene, but he pleaded not guilty.
Okay.
Okay. And a high-profile firm in D.C. took the case for publicity reasons. When I was doing a transaction, an automobile transaction with them, he actually asked me for a loan, if you can believe that. Okay. And when the prosecutor's office in D.C. called me and basically asked me questions about everything because he had told his attorney about me, and he had said, he asked me for a loan. And I obviously rejected him. I told him I have no interest in your affairs, business, and I'm not a loan shark. So, sorry, I don't mean to be comical here. Anyway, however, that being what it was, okay, and I didn't. So here's how my lawyer explained it to me. I had to hire an attorney for this whole matter. It was a pretty serious deal. So I had an obligation to basically walk out of the room. I can't respond to him. If I responded to him and I told him, and I said to him literally, I'm too old for this. It's nonsense. He was involved in the drug trade, and it was not up my alley. So that's called conspiracy. Okay. Not so I had an obligation to basically say goodbye and leave the room. Just me answering him constitutes conspiracy.
Okay.
That being said, he pleads not guilty to the murder. So I went before the grand jury because they had him on many, many drug charges and buys. But but I was the best witness they
Counsel
had.
approach. 1 second, sir. Counsel.
Okay, so I'm gonna interrupt you. Were you charged with something?
Yes.
Okay. Did you plead guilty?
Yes.
Okay. Are you a convicted felon?
Yes, but I got all my rights back.
Your rights were restored.
Absolutely.
When
yes.
was this?
So I was put on probation for 6 months in 2001. So by 2002,
Okay.
all my rights were restored.
Has it left you with, and you don't have to tell us what your impressions were, but is there anything that you would hold against either the court system, the state, or the police because of your situation?
Absolutely not.
That's all I have. Thank you.
Defense?
Is there anything about your involvement either, or just with this whole situation, that you feel would impact your ability to be a juror?
No.
Okay. Anything that you feel like would come into the courtroom and influence your opinions about the evidence?
Absolutely not.
In this case. Nothing further.
Thank you, sir.
Thank you, Your Honor.
Deputy Juror 59. Counsel approach while we wait. Juror 59, do you have a mic, sir? Yes.
I do, yes.
All right, yes. We were talking, so I wasn't sure what happened on the back end. You wanted to tell us something, sir?
Oh, yes. I believe it was jury number 44 who had mentioned he had witnessed a crime, right? I think you brought it up earlier. I have a coworker of mine who last year was stabbed. He survived, but he lost a leg. And, he went to a bar, and as he was walking out, he said hello to a young lady. The partner did not like the answer, so he was stabbed multiple times and lost his leg. It happened so fast, he didn't know what was happening. He just getting stabbed. So there was no pre-med, no nothing, just no intent, just wrong place, wrong time. So I don't know if I can be a biased juror.
You mean fair?
Yeah, I don't think I can be fair.
Right.
I'm being honest.
That's what we asked for.
Yeah.
Any questions from the state? Defense? No. All right, sir, thank you. You can go back outside. Is he gone, deputy? All right, please be seated. Based on all of that, any agreed upon excuse jurors? why don't you announce them? We'll mark them. If the defense agrees, then I'll talk to Mr. Williams about them.
Sure. I would say juror number 2 for language.
Okay?
We agree.
Want me to keep going?
Please.
Juror number 3.
Because of the law enforcement issue.
Law enforcement issue, being a prior victim, graphic photos, all the things that she said.
I thought she also, I don't remember about the graphic photos, but I thought she said she was a victim and she was also a defendant in this court.
Yes, she said that she has trouble with law enforcement. Is fine.
Okay. Anyone else?
We agree.
Okay. Anyone else?
Juror number 9. Emotionally unsure she can handle the evidence.
We agree.
Anyone else?
Juror 17 for language.
17, I have that he just said he wouldn't follow the law, but we can go with language too.
We agree to cause. We agree to get rid of them.
Okay.
Juror 19 for language. Maybe I just got my notes crossed.
Okay.
Yes, agreed.
Anyone else?
Juror 27.
23. The daycare and the language.
I'm going to have Mr. Cossie do them because he probably has way better notes than I do at this point.
Yes. I mean, I don't know. Defense? Defense?
All right, we agree.
2, 27?
27, yes.
Okay. Anyone else?
Agreed.
Okay.
I agreed, but I also think we have 38.
Judge 41 is fine.
Not yet, because I have to have a discussion with Mr. Williams, but what was the other one? Oh. DNA and, right, from the first day. Anyone else?
Yes, yes, yes. Yes, we agree.
Now, 41, it was the one that agreed with 38, right?
Yes.
Okay. I'm sorry, Mr. Classy. Who's the next one? Who's the next?
44, we agreed to.
44. Okay, go ahead. And that's because of her anxiety disorder?
Yes.
Next. The one that just came in and said he spoke 2 languages.
We're not going to agree at this
Okay,
time.
that's fine. And that's with consultation with Mr. Williams?
Correct.
Okay.
Agreed.
With Mr. Williams' consent?
Yes.
Anyone else? Anyone else?
59, the gentleman who just came in.
Mr. Well, I'll ask him separately. Anyone else? Anyone else? I don't have any notes for her. What's the reason? Questionnaire.
And then she got emotional.
Does the defense agree?
Yes, we agree.
Anyone else? 66. Anyone else? Defense?
Judge, defense would move for juror 60 for cause. The reason being, I know he said that he could be fair and impartial, but he also on Friday said that
Here's the issue. If the state doesn't agree, then we have to go through the whole process. So.
I know, I'm just moving for it. That's just.
But right now it's just agreed upon.
Well, I don't know if they are agreeing. Okay.
Do you agree? Okay.
Okay, that's fine.
Anyone else?
No.
Anyone else from the state? Mr. Williams? So your attorneys have asked the court to strike several jurors. I want to. No. Not your actual peremptory strikes. Strike them for cause.
Okay.
You understand?
Yes.
Okay.
That's fine.
So if you want to look at the map, the ones that they want me to excuse for cause is juror 2, juror 3, juror 9, juror 17, juror 19, juror 23, juror 27, juror 32, juror 38, juror 41, juror 44, juror 59, juror 64, and juror 66. Do you agree with those jurors to be excused for cause?
Yes, I agree.
All right, still satisfied with your attorney?
So far.
They're doing everything you want them to do so far?
Yeah, so far I'm just looking for a fair trial to, state my case.
Doing my best to get you that, sir. Let's bring in deputy jurors 2, 3. Am I going too fast? 2, 3, 9, 17, 19, 23, 27, 32, 38, 41, 44, 59, 64, 66. State, did I miss anyone? No. Defense, did I miss anyone?
No.
Deputy, would you bring those jurors in, please? Thank you. Yes. Okay, just ask deputy. The next bunch when we excuse them. Okay, yes, that'll be a good break because I do need one as well. So that works. I appreciate that, but we also need to make sure that you are taking the necessary breaks. just giving a ballpark, do you still think we have enough jurors for trial based on defense?
I think so.
Okay. I'm just asking. Okay. I just also need to know if I need to call up more. You all don't have to sit in your assigned seats, but just I need you all seated so I can identify who's here, and then I have a few things to say. So just everyone have a seat anywhere you want. Council, please be seated. Mr. Williams, you can be seated as well. I'm going to stand because I've been sitting for a while, so I just want to make sure the people that I asked to be here are here and that there's no one missing. Juror 2, Juror 3, Juror 9, Juror 19, Juror 20. Are you here? You're not Juror 20? Yeah, you don't. Could you go back outside, please? You're not 20? She's just, okay. Okay. No, I know we don't have a 20, but she's sitting in seat with Juror 20. All right, so Juror 19, Juror 27, Juror 23, Juror 32, Juror 38, Juror 41, Juror 59, Juror 64, Juror 66. Is there anyone that was not called? Juror 44, yes. And Juror 17, yes. My notes weren't as clear as it should be. You are all excused from further service. Please go down to the jury office. Please let the jury office know that you've been excused from further service with the court's thanks. On your way downstairs, when telling the jury office that you've been excused, please don't tell anyone else that you've been excused. Just go directly to the jury office and tell them that you're excused and you have the court's profound thanks. Everybody's been off one. Bring in everyone else. Deputy, we're going to excuse them for the day and have them come back tomorrow. Thanks. Okay, sorry, I forgot. I too. We both need that break, but I'm trying to. I get in a flow. You get in the flow and you kind of forget. once the veneer is seated and the parties are seated, I'll give the instructions. All right, council, parties, you may be seated. So as you can see, it's 4:30. And if you recall, before we took a break, I said that the defense has equal time, so they have more than an hour. So if we did the math, we'd be here till 6 or 7 o'clock, so I'm excusing you now, to come back tomorrow at 9:30. And the defense will ask their questions of you. We'll have the conference, if you remember from Friday, or maybe it was today. I said that there's a conference where we all meet. You are not present for that conference where we do the actual jury selection. When we'll bring you back, and then we'll identify the jurors that are going to be sworn in to try to decide the case, and then the rest of you will be excused. I anticipate all of that will happen by noontime tomorrow or lunchtime tomorrow. So that should give you a sense as to when the next natural break will be. I wish you all a good night. No texting, tweeting, blogging, emailing, sending, or accepting messages, communications of any kind about this case or your jury service. No discussion about this case. No watching any media, social media, anything that relates to this case. Stay far away from this case. I'm asking you, please, and I'll see you tomorrow. Have a good night. Yes? Deputy will tell you where to meet. And I did tell you 9:30, right? Okay. Thank you. Deputy, let me know when they all have left. Thanks. All right. So in light of all of that, defense, I'd like you to look at the state's opening, the instructions after the jury is sworn in, and just, it's the standard, I'm sorry, and just confirm there's no issues. Opening two. You can review the opening.
I've never discussed that before, but
hey, if I'm offering, right? No, the initial instructions after the jury is sworn in, just to make sure they look to be the standard instructions, so there should be no issues. But I do want to make sure that we have a sort of a seamless process tomorrow. Yes. The order indicates that you all have 30 minutes for opening. Any issues with that? No, and defense. And we will hope to have first witnesses called around lunchtime. All right, so you'll have that lined up. All right. Yes. Anything else to address?
Nope. No.
Mr. Williams, how you doing, sir?
Yeah, just hopefully I could fair trial and I'll be good.
All righty, sir. Still satisfied with your attorneys? Okay, so far you still satisfied?
Well, me and my attorneys have had a lot of problems, but as long as they do their job, then I'm okay.
And they're doing their job so far, right?
So far, yeah.
Well, I'm going to keep asking you, and then you tell me if there's a change, all right?
Okay.
All right, you have a good night, sir.
All right, you have a nice day.
You too.
Okay.
Anything else to address, counsel? Have a good night.